Welcome back to Law News, everybody. We're going to take some time this afternoon to discuss a couple of issues related to the taking down or the destruction, depending on the specific incident, of Confederate monuments in a number of states around the country. Now, there's a couple different ways that these things are coming down. One is a legal process where either a city or a state or a legislative body makes a recommendation or takes a vote to take down a statue for whatever reason they decide. But in some instances, they're being torn down by protesters, and we want to talk about the legal issues surrounding that. We're going to begin our discussion with LaDawn Jones, who's a criminal defense attorney, former prosecutor, and former state representative. LaDawn, it's good to see you back here on the Law News Network.
Thanks for having me. I love coming on Law News.
Well, we always like to have you. So let's talk about the issues surrounding this. And I want to be really clear that not all of these incidents of removal have been really illegal, because in some cases we have legislators saying, hey, look, we don't want these things around anymore. You know, the original meaning of them has been lost or perverted or changed, or the times have changed. People are just uncomfortable with them these days. So we want them gone, and they take a vote to take them down. Now, that's a political decision. And, you know, we've heard arguments. Some people say they should be left there to remember history. Some people saying that they should be left there for other reasons. And some people are saying, yes, get rid of them. But there's a debate in a legislative body about that. And, you know, you've sat on so many different sides of the equation here, former state representative, criminal defense attorney, prosecutor. What's the right way to go about this?
So there's two sides, right? So as states like Virginia, Georgia, and several other southern states that were a part of the Confederacy have laws that were put in place, most of them put in place during the Jim Crow era, particularly after Brown versus the Board of Education, which desegregated our schools throughout the country, particularly in the South. But these laws say that you cannot move, destroy, change a Confederate monument in some cases, and in other cases, any monument on state property without the authority of the legislature. And anybody who knows about making our laws, the laws that we see in our court system every day, it is a big part of it. It's a process that has a lot of minutia in it. And so getting a law passed is a very difficult thing, as it should be, right? So that we can protect our system and make sure that everything is thoughtful. So having to go through the General Assembly or the State Assembly of any state is a very big process. And that was done at the time that those who supported the Confederate monuments were in control. Now, that's one thing. Now, on the other side, as a civilian, we know, looking through our history, it has been resistance and it has been protest that has subsequently changed the law. It was a family that got married that were interracial that were able to do the lawsuit in order to change Loving versus Virginia, that changed the law as far as interracial marriage, right? So to one extent, the law says one thing, but many of our laws in this country have been changed through some type of resistance and a violation of the law in order for it to be challenged in the courts and determined to be unconstitutional.
Certainly, I recognize that, and anybody who studies legal history understands it as well. So, you know, let's sort of pick apart a couple different areas of this debate, because one thing that surprised me is when I started to look into this, there are some states that have passed laws very, very recently about these statues because they knew that there was going to be an upswell of debate, to say the least, about their presence. So, you know, North Carolina has got a law in 2015. That's only a couple years old. Alabama signed a Memorial Preservation Act of 2017. And that law in Alabama forbids the relocation, removal, alteration, renaming, or any disturbance of one of these monuments so long as it's been in place for 40 years. And there's an actual committee that law set up in Alabama that says, you know, you can't do anything unless you go through that committee. And so it surprises me that we've got some new laws on the books that relate to these as well. There's some other states that have other laws that have been on the books that create, at a minimum, some kind of a process. Now, first of all, what do you make of these new laws?
All of our laws typically start from one organization or one state passing a law, and then it's replicated in other states that have the same beliefs. So the laws that put these special designations requiring legislative action started from Jim Crow, but have continued until today solely just because of convenience, right? And these are things where you have to wait until your party is sufficiently in power, where you're able to use the political capital in order to make that change. It also is waiting for Supreme Court to weigh in on these things, right? Once these things get challenged, and once you determine that these laws cannot be challenged on a constitutional basis at the Supreme Court level, then it makes it much easier for other states, once the party who is supporting these rules get into power, to pass them and get them through the legislative process. So it is not surprising. We have to know that there's a discussion about whether these monuments are about heritage or about hate. But you cannot get around the historical fact that these things didn't come about in 1865 at the end of the Civil War. These came around primarily in 1960, right? And as you mentioned, 20 years ago. So between Jim Crow and 20 years ago, the things that were intended to show that there is a separation in our country, that there is still an attempt to secede from our country, to create a nation that is primarily white, or at least a portion of it, is still relevant in our jurisprudence and throughout the laws. And it goes to what the core issue is. The reason why these statutes are important is because it discusses and it shows the systemic racism that was placed into our country through our laws and through actions. And this is one of the final steps at addressing it.
I mean, it does seem bizarre that some of these monuments were built long after the Civil War, when presumably almost everyone who was alive during the time had long since passed. So they were not established to per se honor people who had recently died or when the conflict was still raw. So I think that your analysis is wise in that respect. Now, part of me wonders, though, what kind of repercussions could come down the line for people who have taken it upon themselves to remove these. We're seeing pictures right now on the screen from the situation within the last few days in Raleigh, North Carolina, where protesters went and forcibly tore down one of these statues. And in other areas, these have been taken down by direct legislative action. So a legislature or a governing body at the local level would decide in some places to take them down on their own merits. And as I said before, a lot of political debate has surrounded that, but oftentimes that's decision that's made. You know, there's a presumption that the government owns this thing, it's on government property, we don't like it anymore, we're going to take it down. Or we're responding to the will of the people and saying it's time for this to no longer be given prominent display in an important place in our community. Now, what do you make of these situations like this one in Raleigh, though, where people are just throwing a rope around the thing and yanking it right off the pedestal?
Well, that's the law, obviously, for anybody to come in and yank something off the pedestal. But again, it's a part of creating the law. It's a part of changing the way that our laws are. Now, we saw in Durham where this occurred that it created where several people went down to the courthouse, right, when it was time, in order to say, hey, turn yourself in, because anyone who pulled down the statue has the opportunity to turn themselves in. Dozens of people showed up, right? Which
they're trying to overburden the system and say that they're all involved in it, which is an interesting, perhaps a civil disobedience tactic. I thought that it was brilliant or genius or somewhere there. Wish I had thought of it. If 2,000 people show up and say I played a role in tearing the thing down, how are they going to prosecute anybody who actually did it? But the fact remains that, in theory, if people are going in without the proper, what do you want to call it, permission or blessing of whatever the governing body is, then they could face criminal charges, and that's what we're seeing in Raleigh.
Absolutely. So when you talk about the legality, right, depending on the city or state that you're in, right, this is a violation of state property. This is a criminal damage. In Georgia, we call it criminal damage to property, which depending on the value could be something that is a felony versus something that is $1,500 or less is a misdemeanor, right? So these could be very serious criminal charges that can put people in jail, time on probation, or things of the sort. And people have to be cognizant of it, right? But there has been in our history, I mean, from the Revolutionary War to present day, there has been, it frankly has been the violation of laws that were determined to be unjust, the challenging of those laws that have changed the overall law. And I think that's what we're seeing. But these people, if we talk about realistic 2017 facts, depending on what city or state you're in, and if you don't have 2,000 people showing up to the jail to turn themselves in, you could be facing serious felony or misdemeanor charges for deciding to tear down any statue that is on state property. And that's what we're talking about, right?
Yes.
We're talking about, there's none on federal property. It's only on state property where there are Confederate statutes and things of that sort, with the exception of the Capitol and the White House, where there are people from both sides that are still down the halls of the Capitol. And so it's state law that they would be violating, and in violation of state law, they could be looking at serious penalties for damaging. And so as they get on Facebook and social media and they show their faces, it's a part of the struggle. You have to be a little wiser and a little bit more strategic, or you're facing criminal penalties.
Yeah, and that's the piece of this that I don't know if it's been discussed as much, because people are looking at these things on social media, they're being shared. Many people are cheering these demonstrators, protesters, monument destructionists, I guess, on, saying, look, the large percentage of Americans looking on, at least from my perspective, seem to be saying, hey, you're doing the morally correct thing, but then, maybe part of me is the risk-averse lawyer saying, well, you got to know that if you take the law into your own hands, you could pay a consequence for it. And is there a better way to do it? Is the literal ripping of these things down really an act of final resort?
Right. And it may not be. So we know that in Brown versus the Board of Education and Loving v. Virginia, these weren't just accidental cases. This was a strategic challenge to the laws, that they felt that there was already an argument by case law, by the Constitution, in order to change these things, right? And first, it was the theory that came up with, this is how we need to change the law. Then they picked the perfect school system. They picked the loving family. They strategically picked these cases to take up to the Supreme Court. Now, there are other cases that go before the Supreme Court all the time that change the law that are incidental, but in the area of social justice, it's usually far more strategic. So as people are running out there to participate in these protests and these changes, we have to know if there's been some lawyers that sat down and said, listen, we believe that we can protect you from your criminal damage or felony damage to state property law, because once we take a look at it constitutionally, it's a violation. I, as a lawyer, cannot see a constitutional violation that in some way will protect people legally from doing this. And that's probably why we're seeing in Durham a different strategy, because I'm sure someone advised them that legally our Constitution does not, our Constitution protects free speech.
It protects free speech, but it doesn't protect people who try to destroy property, and that's, to me, it's a different kind of an issue. It's like I said, there's a moral debate that many people are saying the things should come down, but what's the proper way to do it? So if you had a client come in front of you and say, hey, I'm thinking about going down to the town square and ripping this statue down, what would your response be?
So I always have to advise, as a lawyer, my clients what the law is. And I will first tell them that it is a violation of Georgia law in order to damage this property based on where it is, whether it's personal property or state property, and what the penalties are. But then I would also let them know that in order for a case to pursue, they have to prove who was the person who violated this law, right? So if they can't see your face, if they don't know your name, if they can't jump on your social media page and see you post smiling with the statue as it falls to the ground, then they're going to have a difficult time proving it. Now, if they have witnesses that can say they know that John Smith was the person who climbed the top of that statue and helped to pull it down, then those witnesses can, in fact, convict you based on that. Or if there's circumstantial evidence that puts you at the location, like cell tower records and other pieces of evidence that together can show that you were the violator, you can be convicted. And so what I would have to tell someone is A, the law tells you that you cannot do it. And B, in order to be prosecuted for it, they have to prove that you were the person who actually committed the crime. And without the proof of your identity, where your location was, or other circumstantial evidence, then there's no way that the state can find you liable, or a jury can find you liable, nor the state can bring enough evidence to have you indicted for a violation of that law.
Well, let's talk about another issue here, and that's the issue as to whether or not a prosecutor would even bring charges against someone. You know, that's its own sort of a perhaps political decision. You know, a lot of times prosecutors look and say, well, if there's a violation of a law, I'm going to go after it if I can prove my case beyond a reasonable doubt, if it gets to that stage. But, you know, if there's enough there to go after someone, I will. Would you think that there are some places where prosecutors would try to throw the book at people ripping down a statue, or do you think prosecutors would just kind of look the other way and say, it happened, I'm not going to go after this?
So in our justice system, prosecutors, the lead prosecutors are elected, right? And so whether or not an elected official, I think they act far more times as a politician, meaning what do I have to do to get reelected in the jurisdiction that I'm elected in? That, frankly, as a human, comes first. But prosecutors take an oath, both as assistant prosecutors and as the elected prosecutor, to uphold the law. I think that a prosecutor, by law, if they are following that oath, if someone violates the law by damaging this property, they must attempt to present this case and bring a case against them. But now understand, there are several levels to this, right? So even if the police were to take out a warrant, whether or not someone is charged is the decision of the prosecutor. If there is enough probable cause and that prosecutor believes ultimately they will be able to prove beyond a reasonable doubt that this crime has been committed, they have a duty to do something about it. Now, what is that something? It could be going before a grand jury, getting an indictment, and taking the case to trial. But they also have the authority, prosecutorial authority, right? They get to make the decision if they want to do something short of prosecution. They can offer a diversion or intervention prior to even indicting the case or after indicting the case. Prosecutorial discretion gives them the ability to make all of these decisions. So I do believe that if a prosecutor knows of a person who has violated a state law as it relates to these Confederate memorials, I think it is their duty to move forward. But how they move forward can depend both on political pressure as well as their ability to prove the case. And they can decide that they're going to move forward, but allow the case to be set aside, or as a person who wants to uphold the law, prosecute it to the fullest extent and allow a jury of their peers to determine if it was in fact a violation of the law to damage the property. I think that it would be very difficult for a jury to make that decision as it would be for a prosecutor to decide to go forward on it.
You know, I was going to go there next and say, okay, well, let's say, and I know we're talking about a lot of hypotheticals here. We've got what ifs on top of what ifs on top of what ifs, but this is the way our minds work. We try to play out the case to figure out how the law is going to stick to a circumstance. You know, let's say there's a prosecutor who does bring a charge against somebody who rips down a statute. Is this the sort of case that if you were in the defense chair, which you currently occupy, is this the sort of case where you'd be begging for that jury nullification charge, where a judge can tell a jury, if you don't agree that this case should have been brought, you can nullify it, you can acquit, basically?
Right. Jury nullification is a area of law that defense attorneys salivate over, right? We want to one day get that case where we can go to the jury and convince all 12 of them, or 6 of them, depending on what state you're in, to agree unanimously that this law is an invalid law. It is the ultimate level of our justice system of checks and balances. People in the court system can pretty much undermine what elected legislative bodies have decided in a particular case. However, the reality is jury nullification is very rare. It happens very, very often. It's far more a theory than it is a practice. And it will require some of the most top-notch jury selection that any attorney has ever seen. Because when you get a random pool of jurors that sit in a room, you have to ask them just the right questions to be able to establish their bias. And a lot of the questions during jury selection have to relate somewhat, at least, to either jury bias or the particular case at hand. And so being able to ask just the right questions to get that one piece of information to determine if your jurors will be the type of jurors that will overturn a law, basically, by determining that a person is not guilty because the law is unjust. It is legal fiction at its finest.
Well, it raises, and okay, the smile on your face at the end of describing that just was one of the most interesting facial expressions I've ever seen on you, LaDawn. I can tell that you're looking for that jury nullification case. You're looking for it. I can tell that you want it. So that said, my experience has been that judges really don't even like to give the instruction.
That's correct. That's correct, because it creates hours of more time in a jury room where people, on one hand, really do believe that the evidence shows circumstantially or directly that the person pulled a firearm at the gas station, right? Mm-hmm. But there are many jurors who have their own personal experiences, which they are allowed to pull from, that tells them that there are so many systematic laws in our system that are unfair that got us to that point, right? And every time that instruction is given, it gives a juror who may be that holdout juror from a unanimous vote something to discuss and debate, and it takes it away from the facts of an individual case into the facts of our overall system, which can truly be a rabbit hole you can never make your way out of.
Yeah, and there's another moral question I guess we could debate another time as to whether or not the jury's job is to enforce the laws that are passed by the legislature, or whether it's the jury's job to sort of overturn the laws passed by the legislature. That's a side debate we could get into perhaps about another issue. But okay, let's say, as we pile inferences on top of inferences here, let's say somebody rips down a statute. Let's say that they are taken to trial. Let's say they're convicted. Where would it go at sentencing? I mean, I'm smelling something here like community service. Probation. I'm not even sensing, at least from my perspective, that anything really serious could happen, because I did watch, and to a degree was involved with, as a law school intern, some of the prosecution of some members of the Occupy movement, where they sort of overstayed their welcome by many, many days in certain areas. And there was a conviction in the case that I recall, and when it came up for sentencing, the judge just looked and said, you know what, seriously, community service. I mean, I've got to give you something because the jury convicted you, but it's community service. Would you think that something like that would happen here?
In most of the cases. In fact, I would be more surprised if it did not happen, right? And that would make me want to go back and look a little closer at that judge and that judicial system if it really required jail time for destruction of property, with the exception of, we always have to consider, and this is me putting on my former prosecutor hat, what is the criminal history? You can have 10 people involved with pulling down the statute. If you have someone that's been convicted a number of times before for criminal damage to property, for other things unrelated to this issue, I think a judge would have to take that a little bit more serious. But the majority of the time, what you see from the protesters and people coming out for social issues are people without a criminal history, right? And in that particular case, you're more likely to see a judge give a sentence that is far more lenient. Well, let's look at reality. Reality is, many times judges handling these issues are handling rapes and murders, right? They're handling spousal abuse. They're handling issues that are far more dangerous to society, where it is necessary to put the person away in order to protect society and also as a punishment for their crimes. When a judge has to look at a case like this, with someone who has a little or no criminal history, it would be very difficult, and it would be a waste of judicial economy to spend a whole lot of time on whether or not a statute was destroyed, right? And we can take it away from the Confederate monument, right? And the same thing if it were a street sign or if it were a building downtown. Judges are supposed to be nonpartisan. They're also supposed to be unbiased based on not just the facts of the case, but the overall scenarios. Criminal damage to property or whatever it may be called in your particular state should be treated the same no matter whether the property was a Confederate monument or not. And the last thing I will add is that, that's part of what we are afraid of and we're questioning in this moment in time, right? There was a time where someone who damaged a Confederate monument may go before court with a judge who has very strong white supremacist beliefs, with a prosecutor, or even with a defense attorney who has those strong beliefs. And there's a question in our society: are these folks still involved in our criminal justice system and therefore making actions that are race-based or gender-based or sexuality-based, right? Or where your country of origin is. And that's we're talking about monuments, but the real issue is, are these things still permanent in our system?
Yeah, I agree with that analysis. Now, when you sat in the state legislature, first of all, did you have a chance to consider any bills relating to this topic?
Absolutely. So I served in the General Assembly in Georgia from 2012 until 2016. And the viewers may recall that in Charleston, South Carolina in 2015, there was a slaying by Dylan Roof of several people who were just worshiping in a church. And upon the death of those folks, it was right before our 4th of July holiday. And here in Georgia, we have the largest Confederate monument in the United States, the world, the universe. And it is Stone Mountain, and it is one of our largest mountains in Georgia, where on the side of it is Robert E. Lee and several other generals of the Civil War. What's important about this monument is, first, it's a state-owned property. And although it is operated by private industry, it was purchased by the state several years ago. And before it was purchased by the state, this was the place that the Ku Klux Klan in the entire nation was reformed. The Ku Klux Klan died down after Reconstruction, and it was rebuilt in the 60s during the Jim Crow era. And they used this place to burn flags, to burn crosses, to have their KKK rallies, and really rebuilt from a couple of hundred people to several thousand of Ku Klux Klan members around the state. So this location is protected by state law, and you cannot change anything on the mountain without state law. So outside of this huge carving on the side of Stone Mountain, when you walk up the one walking exercise trail that hundreds of people walk up every day, including myself, I've gone up there several times. At the base of the mountain are 4 Confederate flags. The United States flag, which flies a little bit higher, the former Georgia flag, which used to have stars and bars of the Confederate battle flag, and then 2 other Confederate-based flags. And so no matter who you are, you walk up that mountain, at some point you get to an opening where these flags are shown. So I proposed legislation in the 2016 session that would change that. Now, initially, I was for bringing down the flag, getting rid of the carving altogether. But after I did a call for a boycott of Stone Mountain on the 4th of July, I received a lot of feedback from supporters and haters alike. And an 8th grade middle school teacher said, I've always had this idea, but I have not known who to tell. We may not be able to get rid of the side of the mountain, but we can add to it. We can make it accurate and historically correct. And so I proposed a bill that would allow Stone Mountain Memorial Association, which runs Stone Mountain, to change anything on the mountain without going through the General Assembly. That they had to make it factually accurate, right? And for me, factually accurate meant when you fly a flag, when you put up a statue, it indicates victory. Well, the South, the Confederates did not win, and therefore those flags should not fly indicating victory. So making it historically correct will pull those flags down from their poles and put them in a more museum-type fashion with the correct factual contents around it. And the final thing that the legislation did was change it from a Confederate memorial, which is what the law says, to a memorial of the Civil War era. What does that mean? There were women in the Civil War, but they're not depicted in Stone Mountain. There were blacks, both free and enslaved, that fought for both the Union and the Confederate Army. That is not depicted at all in Stone Mountain. And so my law would have changed that. It didn't make it very far because it was not a hot button issue then. maybe now, in light of what's going on, it's an issue that can change. And my goal was not only to change the mountain for those who were against it, but to change it for those who were in support of it as well.
Well said. It's been said many times again that the notion of what America has become and the birth of what we consider America to be really was not so much the revolution, but rather the Civil War. I mean, it led to the post-Civil War amendments. It led to changes in the interpretation of the original Constitution, and the notion of federal supremacy really came out of that conflict. It changed the entire constitutional framework of the country, and I think that encapsulates so much of what's going on now. And a question as to what these monuments mean. So, LaDawn Jones, current criminal defense attorney, former prosecutor, former Georgia state representative, I appreciate your perspectives on this issue because you've been involved with it so much.
Thank you so much for having me. I think it's an important issue. And at the end of the day, as Americans, we have to take a moment, whether you're happy or sad, and delight in the fact that we have a system that can work. We have a system that was well thought out, and whether it's through the passage of laws or the fighting of laws, we have a court system. LawNewz covers very well that no matter what side you're on, you have an opportunity to fight for what's right in this country or change what's right in this country, and that's a beautiful thing, and that's what we're seeing.
Very well said again. LaDawn Jones, good to have you back here on the LawNewz Network. We'll talk to you again sometime soon.